Good evening and welcome everybody. We have a huge number of viewers tonight, indicating the level of interest in tonight's topic. At the end of the Australian Medico-Legal College's first webinar, which was transitioning to Telehealth IMEs, about 90% of the participants voted in a poll that they want to continue the discussion about Telehealth IMEs. The AMLC, that's Australian Medico-Legal College, the AMLC has therefore initiated second and third follow-up webinars. That first webinar 3 weeks ago involved doctors providing tips on how and when to do telehealth IMEs. Tonight's second webinar brings together the perspectives and feedback regarding telehealth IMEs from regulators, insurers and lawyers. Our third webinar will be in 2 weeks on the 21st of May. And will again involve a panel of doctors focusing on when and how to do telehealth IMEs. We expect to have a surprise guest who's a world authority on IMEs and well known to many in tonight's audience. And we extend a welcome to all our participants tonight to attend that webinar in 2 weeks. We strongly encourage everyone who's had experience in this new format of IMEs to email tips on how to do them better. These will be collated, discussed at the next webinar, and used for a position and guidelines paper. The email address is on the Australian Medico-Legal College website, and it's currently on your screen right now, if you'd like to write it down. Any questions we've received before tonight regarding how to do telehealth IMEs will be held over for that next webinar. Thank you for sending in those questions, and we'll address it in 2 weeks' time on how to do telehealth. We welcome the many members of other specialist colleges who've registered tonight following emails from their colleges, and we thank the colleges for having arranged that. And we'd appreciate any tips that the fellows of other colleges might also offer to us, which we'll of course jointly spread around to anybody who is interested to read it. But tonight is about seeking answers to issues raised during the first webinar a few weeks ago, to seek answers from senior representatives of a government regulator, it's the New South Wales CIRA, it's a government regulator, and from an insurer, that's Suncorp, GIO and AMI, and a senior lawyer from Spark Hill Law Lawyers. For webinar participants from states other than New South Wales, you'll hear a few acronyms tonight. They're just equivalent to acronyms that you have in your own states. We have the acronyms of DRS, MAS and AMS, which refer to doctors who've been appointed by the New South Wales government regulators to provide legally binding medical opinions. Of course, that's not all the IMEs that are done, but they're the legally binding ones. CIRA is the joint government regulator in New South Wales for both workers' compensation and motor vehicle accidents. The repercussions of COVID-19 have been thrust on us unprepared. We know that there's still much to be determined, and that some of the questions we're working through as IMEs are also still being worked through by the government regulators, the insurers, and the legal profession, and that not everything can be answered tonight. Similarly, the views of IME doctors regarding telehealth IMEs vary. Some doctors say they won't recommence face-to-face IMEs until they've been vaccinated against COVID-19, which of course might be 6 to 18 months from now. However, other doctors say the opposite. For example, Professor Brian Galton-Fenzi from Perth wrote to us, where legislation requires use of the AMA permanent impairment guides to formally assess range of motion, for example, this must be undertaken directly, and alternative protocols can't be used. Face-to-face assessment is the only process allowing a clinical examination by an IME which is fair. The use of video techniques is not sanctioned by the AMA guides or by the local state impairment guidelines. Dr. Galton-Fenzi said, I see no reason to abandon normal clinical practice and methodology, particularly in the light of the progressive lifting of COVID isolating protocols that are just going on this week. Many other doctors have written similar comments. So panelists, we anticipate that today's webinar will provide some direction to address these opposing perspectives and to identify key issues that still need to be worked through. And we thank our panel members for taking the time to discuss these concerns with us. Audience, For the members of the audience, we'll be asking you to complete a poll on a single important question, or I'll tell you what it is now, but on a single important question, which we'll be sending to your screens near the end of today's webinar. So Sue, I'd like to now hand over the microphone to you. Sue Larson is co-founder of MEDirect and our facilitator for tonight, and she will introduce our panelists. Thanks, Sue.
Well, thank you, Richard, and I'm really pleased to be introducing our panellists tonight, starting with Ms. Leanne Steele, Manager for Clinical Standards and Practice, Health Policy Prevention and Supervision at CIRA. We have, and maybe give us a wave as we go through, we have Mr. Brendan Ford, who's the Executive Manager for New South Wales CTP Claims with Suncorp. We have Mr. Matthew Sison, Partner and part of the Commercial Insurance team at Spark Helmore. We have Dr. Drew Dixon, Orthopaedic Surgeon and President of the AMLC. We have Dr. Nigel Marsh, Occupational Medicine Practitioner and co-chair of the AMLC Education Committee, and of course Dr. Richard Seckel, also occupational medical practitioner and also co-chair of the Educational Committee for the AMLC. So thank you all for being part of this panel tonight. I'd like to welcome you and thank you for coming, and also thank you all our participants who have joined us tonight. So tonight, we're going to be addressing a series of topics with questions that are related to each. And these topics include the following: competing laws and regulations and the impacts on the delivery of the IME. We're going to be looking at managing the limitations of telehealth in delivering reliable opinions, including assessment of permanent impairment, which I know is a question on most IMEs' lips. We're going to be looking at the potential inequalities. So a telehealth assessment versus a face-to-face assessment. How will this be viewed and how will it be managed? We'll be identifying scenarios in which telehealth IMEs perhaps should not be conducted. We'll be addressing the issue of consents, privacy issues, and we'll also be having a look at video conferenced IMEs from a claimant's point of view. And then finally, we'll be wrapping up to look at some predictions or some viewpoints on where telehealth, what telehealth will look like for an IME post-COVID-19. And as we move through each of these topics, questions will be asked primarily of our guest panelists, Leanne and Brendan and Matthew, and then we will throw to our AMLC medical experts for comments and responses throughout as well. Now, there are two pieces of webinar functionality that I would like to draw your attention to so that you're able to get the most from this webinar. Now, firstly, if you move your cursor to the bottom of the screen, you'll see a menu bar like you're looking at on the screen right now. Now, please find the button that's labelled Q&A and click on this. And what that will do is open a question box that looks a little bit like this. Now, we welcome you to submit your questions live as we go through tonight. We will attempt to answer as many questions as we can. However, I will preface that we had a lot of questions submitted prior, which is absolutely fantastic. Any questions that we're unable to get to tonight, given the agenda is already quite full, we will certainly follow up with you with responses, and our panelists tonight have also offered to follow up any responses as well for questions that we're unable to get to. Now, the second piece of webinar functionality is the chat box. So if you click on this icon, it will open a chat box that looks a little bit like this. So, but we ask you only to use that chat box if you're having technical difficulties. Write your comment in the box and one of our team members behind the scenes will reach out to help you if you have any questions. So as I mentioned, it's going to be a very full session tonight. It's made up of questions that have already been submitted in the weeks leading up to this, as well as questions live. So without further ado, let's get started by looking at the topic of competing laws and regulations and the impacts on these on the delivery of an IME. Now, all of us who are here tonight have been affected by the COVID-19 pandemic in some shape or form. And we would all be aware of the federal and state government requirements around social distancing, staying local, travel restrictions. We're all aware of the identification of high-risk individuals and the mandates to adhere to OC health and safety legislations. And I noticed that as of yesterday, May the 6th, CIRA have received 207 notifications of COVID-19 related work-related workplace injuries or exposure in New South Wales, an increase of 3 just overnight, which serves to highlight the importance of all of these measures. Leanne, obviously there's been massive repercussions for CIRA in this rapidly altered environment. And on the one hand, CIRA has had to balance the need to comply with the government directives around social distancing. And on the other hand, maintain its obligations to move the injured person's claim forward, which traditionally has been undertaken via a physical examination. So we'd love to hear, what is CIRA's perspective on this? And how has CIRA been managing these potentially conflicting requirements?
Thanks, Sue. As Richard stated, CIRA is the regulator of both the workers' comp and CTP schemes in New South Wales, and our focus has been on policy and service adaptation to ensure the system is operating well at this time and that injured people and policyholders are informed. This includes guidance to ensure there is no regulatory barriers to insurers progressing with claims management processes and injured person supports. So I will obviously be speaking from the regulator's perspective and can advise that today, late today, CIRA has issued guidance related to the conduct of assessments in this space. CIRA's advice is that attending independent medical examinations is legally permitted at this time. However, it is important in the current environment that there are alternative options. So we are recommending to referrers, which are both obviously the insurers and injured people's solicitors, that in-person or face-to-face examinations should only proceed where determined to be urgent during this time. There are, of course, many factors that contribute to the triaging of matters to determine their level of urgency, including whether an injured person is nearing the expiration of their statutory benefits. Other examples include where an injured person is experiencing financial hardship, suffering a terminal illness, etc. Where an in-person examination does need to proceed, CIRA has recommended in our guidance that appropriate cautions are taken to minimise the potential for transmission of COVID-19, such as screening prior to the scheduled appointment, taking the injured person's history by video or phone beforehand in order to minimise face-to-face contact time, use of personal protective equipment, etc. It is worth noting too that prior to COVID-19, examinations via video were permitted where appropriate and agreed to by all parties, and these were occurring in the New South Wales personal injury schemes. Obviously, the frequency of telehealth examinations has increased in response to the COVID pandemic. However, they were already being utilised.
Okay, thank you for that. So what I'm hearing is obviously the message is to minimise in-person contact as much as possible. If an in-person does take place, it's to minimise the length of exposure and to take all precautions necessary, but also, you know, wherever you can avoid that in-person exposure to do so.
Yes.
Okay, thank you for that, Leanne. Brendan, what is your view on the statement that the personal injury sector can't simply pause for 6 or even 18 months until the medico-legal doctors have been vaccinated?
Well, I'd agree. I mean, it certainly can't be paused, notwithstanding, obviously, anyone that's involved in the administration of the scheme needs to put, you know, their safety. But, you know, as we often see, you know, whilst there's double-digit sort of reductions in the number of claims that are being reported to the insurers, you know, accidents are still happening. We've had some very high-profile, very recent, you know, tragic car accidents. We still have a number of workplaces that are open and operational around the country, and you know, injuries are occurring, and you know, and they're occurring with tragic consequences, loss of life, we've got catastrophic injuries, and you know, people rely on the safety net of these compensation schemes to look after them when these events occur, and you know, rightfully.
Can I just stop for a second? We're getting a lot of messages, Brendan. People aren't able to hear you, and I can't either. Are you able to come closer to the microphone, please?
Is that better?
That's much better.
Much better.
Yeah.
Yes. Thank you.
I was, for those of you who didn't hear, you know, whilst numbers are down absolutely, and we're sort of getting double-digit reductions in terms of claims, there are still tragic accidents occurring on the road. There still are, workplace injuries occurring with all sorts of much frequency. And, we provide that service. We provide the safety net for people that, are reliant, even more so throughout this time. So it's, we've been classified as essential workers, and, personally quite proud of that, because it sort of reinforces to us and to the people that work within this scheme the importance of the work that we do. So it absolutely can't close down.
Okay, so a clear message for you is you have to keep going. You have to keep, although claim volume has changed, has reduced during this period, you have to keep proceeding. So given the conflicting scenarios that we've been talking about, where we need to try and minimise in-person consults, but we obviously need to keep the assessments moving forward. What have been some of the challenges for the Suncorp Group in meeting your claims objectives during this period? Also, what kinds of initiatives and recommendations and requirements has the group put in place for managing safety aspects, and particularly, for the injured person and for the IME? And I will note as well, many of the IMEs are also in the high-risk group. So what's your position on this?
Yeah, sure. Look, the challenges have been considerable, and I will say this: I think that the whole industry has responded, really well. CIRA have been really, responsive and directive, and provided certainty where there hasn't any. Nearly all of our stakeholders, have been able to, mobilise and respond to this new way of working. The challenges for us are probably no different to any organisation. First and foremost, our people, they work as frightened and concerned as everyone. So ensuring their well-being and, moving thousands of staff to work from home has absolutely, presented some challenges. A large organisation as thankfully has the infrastructure to be able to respond to it. But even having a number of people working from home, presents ergonomic issues. We have a number of staff that don't have the luxury of being able to work from home, have got their working parents. They've got all of the challenges that go along with that. As I said, we've been able to respond to those. A number of the objectives that we have, they absolutely, the medico-legal component is an absolute critical component of this, and I will focus on that. But there's obviously lots of other challenges that we've had, even about facilitating treatment for injured people. So some of the things that we've really done is to and this can be quite easy because CIRA have responded. Well, we are able to defer. Nobody's been put under any pressure, and certainly we've been following all of the advice from the government in terms of there's been lots of cancellations of appointments where people have felt unsafe. We've followed those guidelines and absolutely given them clarity that they don't need to attend appointments. And it's exactly the same with the IMEs that we use. It clearly supersedes notwithstanding the importance of the work that we do, their protection. We have agreed to assessments. We've had a number of lawyers ask us if we would accept the validity of an AV assessment, and we've absolutely supported that and said we've used this at telehealth facilities for some time. They have proven that they can actually work. It's not to say that always the reports are right, but the actual mechanism for doing them, no objections to. So we have been supportive of that. And we've really looked to provide financial assistance to those customers that need it. We segment the portfolios by those that are most at risk, and we've reached out to them, people in hospitality, people in industries that we know that they've lost work. We've provided financial hardship, and our job is to pay claims, and we're looking for creative ways that we can actually do that, even where there sometimes there are some gaps in the evidence.
Okay, thank you for that, Brendan. And so I guess what I'm hearing so far from Brendan and from Leanne is that, at least from a logistical perspective, and we will certainly spend a lot of time on this video conferencing looking at the practicalities from a medical perspective, but what we're hearing right now is that from an insurer perspective and from a regulator perspective, video conferencing is certainly an option. It's not a lesser option. Well, I won't say that. At this stage, it's an acceptable option for doing an IME assessment. I know that a lot of the participants who are on the call tonight are going to be interested in the legal perspective though, and we've had lots of questions around, is it as valid? Is it more open to dispute? And we'll get into a lot of detail around that. We'll also get into a lot of detail around, can you practically, from a medical practitioner's perspective, reliably undertake an IME via video conferencing. So please know, we will be talking about that. But Matthew, from a legal perspective, I know that there's a lot of questions there around, you know, what's the legal profession going to do to a consult that it's undertaken via video conference? Given the conflicts that we have, how do you rationalise it? How do you balance the current scenario and the need to keep things moving forward?
From a legal perspective overall, there is a much larger picture that this is taking place within, and I think it's handy to just look at that picture briefly. And there's probably two limbs to that picture. One concerns the impact and the nature of the changes, and the second is trends that were in place in the legal environment that preceded the COVID scenario. In terms of the impact, taking evidence via telehealth, via any means other than direct face-to-face scenarios, or entering into dispute resolution scenarios other than in face-to-face settings, is a massive change. For centuries, our legal system has been built around and predicated on principles in which we accept that judges and decision makers can look at people and judge and assess their behaviour and their conduct and form really important decisions based on those sorts of analyses. That's why we have, you know, some of the best barristers are known for their flair or the way they dress or the way they speak, and they do, you know, speech courses and acting courses and all sorts of things, because they have been pivotal aspects of the way our legal system has worked for a long time. So these are quite striking changes when viewed in that context. In terms of the trend scenario, despite me having said how considerable the changes are, in terms of the trend, this was happening well before COVID came along. For example, in 1999, when the current motor scheme, or actually the just recently finished motor scheme in Sydney or New South Wales was introduced, the absence of a party or a witness from a jurisdiction was enough to take a matter away from cars and bring it into the courts. Oh, that was introduced in 1999, and over the course of recent years, we've seen less and less emphasis placed on that avenue for exemption of a matter and bringing it into the court system. Anecdotally but reliably, I can tell you that there's been a dramatic increase in the last 5 or 6 years of arbitrators and judges being willing to take evidence through AV mechanisms. So moving, you know, 15 or so years ago from an extreme reluctance to an almost ambivalent approach to it in terms of its comparing it to face-to-face evidence. So this is part of an overall trend. Now, there's no doubt that COVID is acting as an accelerant and a catalyst and pushing this along, but it's a scenario that's been developing for a while.
Okay, so from a legal perspective, it's part of a natural progression. In
Yes.
your perspective, it won't necessarily be the thing that causes something to come into dispute. The means of the means under which the IME was undertaken is not necessarily going to put an examination under more risk of dispute.
I know we'll touch on on that sort of question a little bit later on as well, so I might reserve some of what I was saying in relation to that, but we also can't sugarcoat the fact that we're in an adversarial system, and even the new Act in New South Wales is to a substantial extent an adversarial system. If the legislature wishes to move away from that to a New Zealand or a Victorian style scenario, they can do that. So in answer to that, Sue, there's no doubt that if there's any scope to locate a weakness within a piece of evidence, one of the parties are going to do that. That may come about because it's done by AV, it may come about because it's done face-to-face. But we certainly can't say that there's not going to be arguments brought to bear simply built around the fact that an assessment is or is not done via telehealth.
Okay, thank you for that. I'd like to touch on something that Richard raised in the introduction, and it was a concern that was raised by a couple of doctors, a significant number of doctors, and with the comment being that where there is a requirement in legislation to use the AMA guides for the assessment of permanent impairment to formally assess range of motion, for example, this must be undertaken directly and alternative protocols cannot be used. Face-to-face assessment is the only process allowing a clinical examination by an IME, which is fair. The use of in-camera techniques is not sanctioned by the AMA guides or by the state impairment assessment guidelines. Matthew, what are your thoughts on this?
I'm sorry, Sue, I'm going to have to ask you to repeat the final part of that question. I was actually just reading a comment from some of the comments that were coming up on the screen.
Okay, sure. So it's in regards to the AMA guides and the assessment of permanent impairment to formally this range of motion. So, you know, what is your comment in that that the AMA guides don't necessarily sanction the use of video conferencing? No, look, as Leanne mentioned earlier, CIRA has been using telehealth for some period of time. The AMA guides, particularly AMA 4 from 1999, which is one that I have some familiarity with, talks about the objectives of the assessment, quality controlling of aspects of the assessment, quality assurance, but it is largely built around the objectives, and it doesn't stipulate how those objectives are meant to be achieved. So just as a primitive example, if the objective says assess range of movement of a particular joint using a goniometer, it doesn't say the goniometer has to be held in place by the practitioner. Is it possible for the goniometer to be held in place by the claimant themselves? If that is the case and the doctor agrees that that's adequate, then it's going to satisfy AMA 4 in that respect. AMA 4 doesn't say anything, and I actually had a look at it today just to check this. I can find no references in there to telehealth type scenarios, and given that it was done in 1999, that's perhaps no surprise. Okay, thank you for that. Leanne, what's your view on that question?
Look, the assessor must be confident that the method of assessment they've proposed to undertake will ensure accuracy in their examination and the resultant report. In making this decision, the assessor must use their clinical knowledge and consider each situation on a case-by-case basis, factoring in a number of elements such as what is the purpose of the assessment. As Professor Galton-Fenzi has pointed out, where an assessment is of permanent impairment, it must comply with the relevant guidelines, but as was just said, that those guidelines may be interpreted in different ways. Other purposes of assessment, such as providing an opinion on liability or the appropriate proposed treatment, may be more appropriate to telehealth. But to determine this, the assessor must also consider the injured person's unique circumstances, primarily their injury or injuries. So what is their diagnosis? What are their reported symptoms? For instance, if they report neurological symptoms, that may be an indicator for how extensive a physical examination would normally be undertaken. There are also other factors that need to be considered in the decision, such as whether the injured person requires an interpreter or professional support at the time of the assessment, and or a care or support person in the assessment. So that will also impact on whether telehealth may or may not be appropriate. And also, of course, the injured person's access to and familiarity with software and hardware if a telehealth assessment is likely to be utilised. And then, of course, that's all framed within the current advice from the Australian government and New South Wales government in relation to COVID, including any public health restrictions in place, travel restrictions, etc. And another consideration is whether a combination of methods can be used, such as we referred to before, such as taking perhaps the oral history by telephone and then conducting a physical examination in person, just so again to reduce the time of the examination.
Okay, thank you for that. I'm just going to check in with a couple of questions before we move on to the next section. And I'm going to throw this open at the moment. The first question is it our, as an IME, duty of care that a client is not at risk of getting COVID from an IME? So does an IME need to be mindful of exposing the injured individual to risk? It's a difficult one. Brendan.
Yeah, look, it is a difficult one. I think the simple answer is yes, obviously, but, you know, I don't think there'd be any IME that basically would obviously willingly do that. So it is a difficult one, and obviously putting anyone's, you know, safety or well-being at risk is it probably isn't going to be the issue. Some of the questions there about IMEs, they absolutely need to protect themselves and should be doing that. And they've got an obligation to themselves and their patients. So, you know, whatever the right mechanisms are to, you know, to enforce and ensure that happens, yeah, they absolutely have to be met.
And from Sarah's perspective, we've received feedback from some assessors as to those who are still undertaking face-to-face examinations, that most of them are putting measures in place, such as using personal protective equipment, social distancing wherever possible, conducting the history part of the assessment by telephone, screening injured persons before they come into the rooms to just check, you know, if they've had any exposure or symptoms, etc. So most of them are taking measures to try and reduce the risk to both the injured person and obviously the assessor themselves and their staff.
Okay. Okay, thank you.
The duty of care is no different to the duty of care not to cause any other sort of an injury to the claimant. It's a matter of the practitioner exercising their skill and expertise to ensure that that doesn't occur in the particular circumstances.
Okay, so if there would ordinarily be no increased risk, then it's the same scenario. It should be approached the same way. All right, look, we're going, there's been a lot of questions that are now starting to look at the limitations and managing the limitations of telehealth in terms of when you're undertaking examinations. So I'm going to move on to this section here, and a lot of discussions around conducting reliable IMEs via video conferencing, and that's been a key consideration for most IMEs, particularly most who would be on the participant list tonight. Now, some IMEs are reasonably comfortable determining most ranges of motion via video conferenced assessments, such as, I think, Matthew, you mentioned holding a goniometer, in this instance up against a computer screen, or by taking a photograph of the claimant's position, measuring the range of motion later. However, when determining the impairment ratings, there are other physical signs that an IME needs to determine, which are far more challenging via video conferencing, and in fact some would say unable to do. And these are things like muscle spasm and guarding, tenderness and sensitivity, muscle wasting, reflexes, joint crepitus, ligament laxity, and certainly undertaking reliable tests for things like impingement and Tinel's for carpal tunnel. Most IMEs would say that they don't feel that they can accurately determine those aspects via a video conferenced assessment. However, we do still need to keep determinations coming through. We do need to continue with medical opinion to manage claims of injured individuals. So I'm going to start with you, Matthew. What is the current approach or thinking around, you know, how to balance these limitations in the current environment, and from a practical perspective, and considering the legal aspects, what should an IME do to manage these limitations where there are some aspects that they can comment on and some that they can't?
I think it'd be quite handy, Sue, for us to differentiate between assessing impairment per se, which is where AMA 4 comes in and is very much, although it's medically mediated, impairment as a percentage is a legal construct, versus a doctor offering, say, general opinions concerning work capacity or domestic capacity or diagnosis or causation, for example, or prognosis. When we're dealing with impairment as such, with percentage impairments, it simply seems to me that at this stage, perhaps the way the regulations, the way the law is structured, the way the dispute resolution scenarios are structured, I'm not convinced the industry is ready yet to move to a scenario where we can confidently have a system that creates binding impairment assessments, which are extremely consequential to the claimant, via telehealth. And looking at the questions, there's all sorts of issues that have been brought up that are explaining why that may or may not be, and I'm sure they'll be talked about more tonight. I'm far more positive about the ability of practitioners to prepare comprehensive medical reports on just about every other issue that they might be asked about. But I think impairment, largely because it's a legal construct, is quite tricky.
Okay. Brendan, I'd love to know your thoughts, not just on impairment, but also, is there a difference when you're determining other things like causation?
Look, there absolutely is in relation to that, but, you know, we need to listen to the experts. The insurers aren't, and you know, it comes down to the doctors, where where there are limitations, you need to tell us. You need to be absolutely clear what can and can't be done, and obviously that needs to be worked through. And you know, as already been referenced, there's a very sort of polarized opinions on what can and can't be done. I mean, I'm generally a bit of an optimist, and I think all of, you know, the systems that are in place, there are imperfections with a lot of them. But again, having worked in some personal injury schemes overseas, you know, we should be very proud of the schemes that they have, and they've all had limitations, and they all have areas, you know, that require improvement. I think there is absolutely a view that a number of physical examinations is going to be a challenge. If you hear what people's views in terms of psychiatric consultations, fairly straightforward, a history. You know, large parts of the legislation, and I think it's probably the same everywhere, there's a real focus to rely on treating doctors, treating reports, and to really utilise those and using IMEs to support them. And where there are, you know, gaps and, you know, nature abhors a vacuum, and, you know, they will find a way of resolving those things. But I think it's you know, we'll focus on the cases that, you know, there are issues, but I think we need to focus as well. They will be the exceptions, and I think that, you know, they're the challenges just need to be put forward. And yes, they'll need to be deferred, they may need to be delayed, and they may need to work for face-to-face, but solutions will present themselves.
Okay, fantastic. Leanne, as a regulator, what's your perspective on how we distinguish between these, how we manage these, how we manage the limitations? If a doctor feels that they can undertake a certain proportion of the request, the referral, but not the others, what should they do, and how will this be managed moving forward? So how will that particular report be considered?
Look, as I said before, an IME needs apply their clinical judgment in this situation. So the doctor needs to be confident that they can complete by video all the required components of the examination to inform their opinion for each particular injured person if they choose to use this method of assessment. Now, where they feel that they can't do that adequately, our suggestion is that they would talk to the referring party and give that feedback, and therefore it may not be appropriate for the assessment to proceed, or perhaps there needs to be a face-to-face component in some situations. So obviously they determine that on a case-by-case basis, depending on what the purpose of the referral is, and as I said before, the individual injured worker's circumstances, such as their diagnosis, injury type, etc. But essentially the doctor needs to determine if they can be confident in any conclusions they are making in their report, and if they can't, not undertake the examination by this method. So they need to be able to ask themselves the question whether they can stand by their findings in a court if the matter is disputed.
And I'm looking at a lot of the questions, thank you, Leanne, about doctors making comments, some saying that there's a lot of the assessment that they can do, others in their particular area of specialty or specific scenarios saying that they can't assess it via telehealth. And very much what I'm hearing from you is that as the medical expert, it's the medical expert's role to determine what they feel they can confidently comment on, and if they feel that they are unable to undertake the assessment via video conferencing, then they should either not do it, or they should comment on the aspects that they feel they're not able to address.
Correct, yes.
Okay, and I know, yes, Matthew.
Just further to what you mentioned then, Sue, just picking up something you said, ultimately the extent to which this carries forward and the long-term infiltration of this sort of methodology into the industry will depend on the doctors. The medical profession is ultimately going to have the say here. The best way I can explain that perhaps is just to think of a hypothetical scenario. Imagine a practitioner somewhere invents a machine that he says can objectively and definitely measure a person's pain. So there can be no questions about whether a person is experiencing pain because the machine can measure it. That machine would be adopted in a litigation scenario. There would be doctors arguing for and against. Slowly through the common law or quickly through some sort of legislation, it would be adopted or it would be rejected. If it's ultimately adopted, it becomes a part of the system. That's the same, that's just a metaphor for what we're dealing with here. And I'm seeing these questions with different sorts of professions seem to have different approaches. if particular parts of the profession or different specialties speak with one mind, there's a greater degree of likelihood that those specialties will start delivering more telehealth scenarios. If there's a great deal of controversy among them, then it's likely that the judiciary and the decision makers will fall back on old methods. So it will really rest with the different specialties and with the medical profession to form a view about whether this is effective, and then to ultimately, in the course of time, convince the decision makers that that's the way it will happen.
So ultimately, it's the medical expert's decision, really. If the body of medical experts determine that it is not a viable means to move forward with IME assessments, then that will be where the resting place ends. If for other scenarios, the body of medical experts can find a way to confidently deliver their opinion, then that will be what moves forward. And I agree. I'm looking at a lot of the Q&A, and I'm looking at some of the aspects of the chat, and certainly there are some contributors who are saying that there's a lot they feel that they can do, and there are others saying that they can't. And so it could well be that it comes down to specialty. It could well be it comes down to the type of assessment being asked. It could well be that if it's regarding IME, then it may fall into the no, don't feel I can do it. But if it comes down to causation or treatment advice or work capacity, then it may be appropriate to do so. So I think at the moment we're just still it's still very early days. I mean, we're 6 weeks in to this. And I think that's the point. We're still all trying to work through what can, what can't be done, where is the application. And so I think your comment that I'm hearing from all of you is that at the moment, we're not sure. We just have to try and minimise in-person contact. If you feel that you can't do that and you're prepared to do a face-to-face, then that's, as a medical expert, that's your appropriate decision. So still a work in motion very much.
Can I bring in a very quick comment here?
Yes.
As all other parties other than the doctors are saying, that it's really up to the doctor to decide. There's a very big practical issue here. We commonly will get very many documents sent to us. Can even be a box full of documents sometimes, and usually quite a number of documents. We would have to spend quite some time reviewing all of that to come to a decision. If it's actually going to be up to us to decide that we can or can't do it, we're either going to spend quite some time, which would be, I presume, unpaid if we're going to say that we can't do it, or else there should be some sort of a funding system, or else alternatively we just say, no, look, we'll do as much as we can with every case that's sent to us. And a significant number of those might not be able to have permanent impairment assessed, for example, but we'll do everything we can. And because the time spent in reading the documents and perhaps considering all those other issues is a very substantial part of the time that we're investing in each of these cases. So if it's going to be left up to us, I would suggest that every case that gets sent to us, we would have to be able to submit some level of reasonable fee depending on the time taken already, just to come to the decision that we can't do it in those cases where we say that. Any comments from anybody else about that?
So Leanne from Sarah, I mean, the guidance that we issued late today is basically saying that the initial responsibility is on the referring party to really think clearly about, as I said, the purpose of the assessment, the urgency of the assessment, and taking into consideration all the injured person's particular factors, injury, how at risk they are, whether they're in an at-risk group, etc. So hopefully, if the referring party takes all those steps and really does think carefully about it in the first place, hopefully there will be less instances where that sort of material will come to doctors for them to then have to review and make that call.
So just to clarify that then, the decision based on that is actually not the doctor's, because much of the conversation up to now has been it's up to the doctor to decide. I think the decision is made by the referrer, and then the doctor decides how much of what's been requested of the doctor can do, but there will always be some part of what the doctor will do. I mean, there'll always be some matters that a doctor can address just on documents alone, even if we didn't do the video, but of the documents alone, plus taking a history, etc. There are some parts we could do, and once it's been referred to us, then there is some item being raised for that service or service happening. Okay, so it's not the doctor's decision. Actually, from what you're saying, it's not the doctor's decision.
Well, I mean, once the referrer has identified a need for an assessment to proceed based on whatever factors that they've considered, the doctor obviously still has the ability to decline that referral, because when a referral comes through, there's obviously some context to what the purpose of the assessment and the questions that are being posed. So from that and just some brief information about the injury type, etc., the doctor hopefully would be able to make a call on whether they can go ahead or not, without going into the detail of reading, as you say, extensive amounts of material.
Okay, well, I would suggest that you really have to read it all to be, or the great majority, to be able to make any decision. But the decision then will be up to the doctor, how many of the questions the doctor can answer, rather than whether the doctor should open the file in the first place. I would suggest.
We may well see, Dr. Seckel, a whole new type of clinical expertise brought to bear, which is having read the material at the start, and you're right, obviously a doctor should be reimbursed for doing that. The doctor makes a call as to whether or not he thinks an AV assessment is going to be appropriate, and it may well be the case that letters of instruction need to routinely contain a question asking the doctor to comment up front whether or not an AV assessment is appropriate in the doctor's opinion. If that's not done, I don't think a practitioner should ever hesitate to either ring the referrer and say up front how they think the examination should proceed, or alternatively in the body of the report identify deficiencies in the process at that stage because they need some other form of examination.
But some service will have occurred already at some stage.
Yeah, that's right. And that's something that we're obviously going to have to look at.
Okay, thank you.
All right, so look, let's move on to another challenging question that has been submitted by one of our participants tonight, and that's regarding the potential challenges determining accurate thresholds in motor vehicle and work cover matters where the examination's been conducted via video conference assessment. So, for example, in New South Wales, it is feasible that a motor accident injury that's assessed at 10% via a video consult, which is the threshold here for New South Wales motor vehicle accidents, may be assessed at 11% if the assessment was conducted via face-to-face, or vice versa. It could go the other way. And this can make a massive difference on the outcome of the claim here in New South Wales, and it could be the difference between hundreds and thousands of dollars for the injured individual and for the insurer. Of course, other jurisdictions have got different thresholds, so the principle still applies regardless of where you're conducting your IME. But it raises the issue of procedural fairness, as the claimant may indeed be disadvantaged or advantaged by having their assessment conducted via video conferences. And it also potentially raises the issue of increased likelihood of dispute, because of the likelihood of reliability challenges for a video conferenced assessment. And even without video conference, these are the kinds of assessments that routinely get challenged, where there's, you know, somewhere in the range of 8 to 12%. So there's a lot of issues involved here when you're looking at close threshold kinds of determinations. Leanne, how do we manage situations like that? And totally noting that your particular area of expertise is around the DRS assessments. When it's a close threshold and it's undertaken via video conference, is there potential to consider a range? Do you think it will have any difference whatsoever? What's your view?
Look, once again, case by case basis. Currently, the DRS are conducting the majority of the psychiatric assessments by video, so they don't see that the method of assessment is a barrier with those types of injuries. They also have some examples of obtaining agreement for physical matters to proceed on the papers, sometimes with accompanying video assessment. But that's mainly for treatment disputes and for causation decisions. In these particular examples, the injury or the level of impairment is not in dispute though, so they can proceed without in-person physical examinations as the parties agree to existing findings. But I actually spoke to DRS and they said they can't really comment on threshold issues. It really does depend on a case-by-case scenario. So once again, it's up to the referrer and the assessor to determine whether it is or isn't appropriate to proceed with those types of assessments based on their clinical knowledge and their experience in these matters.
Okay.
So there's no black and white answer on it.
Brendan, what's your view as an insurer?
Well, look, you know, in terms of the impairment, it is difficult because, as you rightly say, the difference in 1 percentage point, you know, can start up at about $150,000, and every case and, you know, every person is unique. There has to be procedural fairness. So if the report, I mean, and these disputes occurred irrespective of COVID and the situation that we're in. If the report, so all of the, you know, the options that Leanne's, I won't repeat them. There are lots of assessments done on papers that we can. But if the
sorry, Brendan, could you come closer to the microphone again, please? Thanks.
If the report is correct and it is been done the right way, then there should be certainty there. There shouldn't be a case unless, again, the experts say I'm unable to assess certain parts because I need to see the person in person, then they need to be deferred until then. You can't really give discretion on those things because it is very difficult. So definitely case by case basis. But again, if the quality of the report can be done, we've all sort of, you know, a general consensus that psych does work in that, and, you know, even a lot of the physical ones on paper, we have found that the reports are technically right. We have people assess them based on, you know, the guidelines, and there's every reason to accept them. If we find that it's under or over and the report, they haven't, you know, new information, then they do need to go, they will need to go back to those, you know, forums for the appropriate decision to be made.
Nigel, what's your view on this? Obviously, as a practitioner, you're kind of in the hot seat when you're in a threshold decision. What's your view?
Yeah, look, I agree. When you've got a figure which is close to the threshold limit, then everyone's going to go for an appeal if they possibly can. But I think you've got to sort of look at these things sensibly. And I can see situations, for instance, somebody has a neck injury and hits their knee, and you can make a the assessor say can make a pretty robust argument that the neck is a DRE 1 or 2, which is a maximum of 5%. The knee, the person's still complaining of some pain there, but it's got a full range of movement. The question, say, of retropatellar crepitus may come up. Well, if there is crepitus there, it's worth 2%. If it's not, it's 0. But obviously, the assessor cannot assess that in an AV assessment. But whether it's an extra 2% or not, it's not going to make any difference to the threshold. And I know it's MAS assessments are appealed when there are faults found there or questions found there, and then they're not going to make any material difference. But I think under these circumstances, making an appeal in that sort of situation is really rather fatuous, and it goes against what I would call common sense. I don't know, how would you feel about that, Leanne?
Yeah, look, yeah, I don't disagree. And look, as I said before, there's already been video examinations undertaken in the personal injury schemes pre-COVID. And I'm not able to comment whether any of these have involved issues around threshold or have been challenged in a court. And if so, if they were challenged on the basis of the method of assessment utilised. Certainly no one has said that they're aware of that during this webinar tonight. And of course, CIRA is not able to comment at this stage regarding the likelihood of disputes of assessments undertaken by video in the future. But we have now introduced some coding for IMEs that have been undertaken by video. So we will be able to track, obviously, how often video assessments versus face-to-face are being utilised from here on in. And we can also then track the progress of those claims and see what ends up happening to them. So, but that will take some time, obviously, for that intelligence to evolve as the data builds up. Plus, obviously, dispute matters, court cases, etc., take time to be completed as well.
But would you be in a position, your arbitrators, disputes resolution officers, to then dismiss an appeal in such a situation where you know, it's just not going to make any material difference, and it's a pretty robust decision? Or would you feel that you know, because the examination couldn't be done fully, regardless, that the appeal must be upheld?
Are you asking that of me? Because I can't answer that question. Sorry.
But you're the ones that look at the appeals and decide whether there is a case or not.
Yes, but I can't comment on
No,
that.
okay, well,
Sorry.
okay.
In terms of when you're referring to those appeals, Dr. Marsh, there are two things in the New South Wales scenario, for example. One is if there's an error in the assessment, we can have it redone.
Yes.
But that has to be an error. So if for example, telehealth is identified as being adequate, there's no actual errors identified in the assessment, then the assessment is not going to be susceptible to any sort of review process. What the New South Wales system also allows, and I've had experience with this, is for a further assessment to be done if new evidence emerges. And I have had a scenario where an audio-visual assessment was done of a claimant in another country. The insurer wasn't satisfied with it. The claimant returned to Australia, and we said that by virtue of the claimant's body being back in the country, we had further evidence. And CIRA accepted that at the time, so we had it reassessed.
Yeah.
So I wouldn't be overly concerned about questions around errors, because if the normal procedures are followed and everything is done normally, that's not likely to be an issue. I'd be far more concerned with what constitutes additional evidence moving from audio-visual to in-person. And as I said earlier on, that's a situation where the regulations just aren't ready for this scenario yet.
Mm.
Any other comments from our doctors on this issue? And I know that there's a lot of comments in the question box around, you know, these kinds of challenges and the parameters around, you know, needing to palpate the injury to get the finer points. Drew, do you have any additional thoughts around this matter, and any of the ones we've spoken about so far around causation and around the impairment rating?
Well, I think it's important, as Richard's addressed, that you have all the documentation. And it's important that you pre-read the documentation so it helps with consistency when you are examining the claim, whether it be face-to-face or by Zoom or by Skype. The other thing is that when everything is close to a threshold, it seems to me there's forensic ferocity coming from one side or the other. This is not necessary. You can politely disagree. You can say what you think is the important issue, and you can send it back for reconsideration if there's an error. It doesn't have to go all the way through to the keeper and go to an appeal panel. What it should be done is to set a simple thing. Might be numerical error or transpositional error from the narrative to the table, or it might be omission where the person's lumbar spine has been examined and doesn't appear in the table. These things could be solved by reconsideration. The other thing is that it's important that when there is an appeal of an assessment, the issue is to be identified, and that is the thing to be answered. What is happening sometimes, and this particularly applies to motor vehicle accident cases, they take the view that they can look at the one issue, but then they might decide to re-examine and do de novo assessment and then take the whole case to be re-reviewed. Now, I think that is unfair to the assessor. I think what should be done is that the issues that have been raised by either party, the things that should be addressed. Now, if there is something that can be relied on that gives the claimant a higher WPI, for example, then the guides tell us we have to favour the higher level. Now, one of the big problems is that you may have an X-ray, a weight-bearing X-ray that shows considerable narrowing of a joint that gives them a higher assessment than you can on physical examination. And so that enables the assessor to go to that, measure that, and then give a figure. The other thing is people talk about carpal tunnel, and the thing is the only test for carpal tunnel that's reliable is a nerve conduction study, because it varies from day to day what the claimant's been doing when you assess them. Have they been in the factory all day, or you're seeing them first thing in the morning when they've slept on the arm, etc. So the thing is, we've got all the evidence that we have sent to us. We've got all the documentation. We pre-read it. We're looking for consistency. But don't forget the other evidence there, which is the investigations. So that what we're doing is looking at an overview. We're taking all the evidence into consideration to form that opinion, which is based on your clinical experience and knowledge. Now, there are threshold issues, and Nigel's addressed that. But sometimes we get sent somebody who has another problem that's escaped, shall we say, discovery, or there's something there that has been missed. Now, if it's in the documentation, you can address it, but if it's not, then it has to be investigated, and that means it's got to go back to the referrer to see if further investigations can be done and that both parties are fully aware. My view is that if investigation is deemed clinically necessary, then it should be done, but it should be done with both parties being in part of the process, but it not necessarily has to be done, but it could be pointed out that it may be done. Now, this might be something that is not necessarily pleasing to either side, but sometimes there is things that have been missed that aren't in the documentation and they need addressing.
Okay, thank you. Thank you for that. We're just going to do a quick whip around with a couple of scenarios, just a quick 30-second thoughts on them. What happens, Matthew, this one's directed at you. What happens if one assessment's being conducted via a telehealth assessment and the opposing one's being conducted face-to-face? Would you consider that an inequality? What do we do about that?
It certainly could be, depending on the scenario, depending on the circumstances. We're commonly told by judges and arbitrators that treating practitioners should be preferred over medico-legal practitioners' opinions, because the treating practitioner may have known the claimant for a longer period of time and have spent more time with the claimant. So you can see quite readily from that if two reports are presented to a decision maker and one involved a consultation and one didn't, the same sort of conclusions could be drawn. I think it's, there are things that practitioners can do to mitigate those risks in their reports, as we said earlier. I can't emphasise enough how much I appreciate and welcome telephone communication with doctors, either before they've started their report or while they're in the process of doing it. The doctors can acknowledge weaknesses in the evidence during the course of their report and acknowledge that there are some questions that they can respond to better or more comprehensively than others. They can make recommendations concerning further examinations or further things that need to be done for them to refine their opinion. They can, well, it's a horses for courses case, I think, in terms of the sorts of claimants that are being presented to the doctor on a case-by-case basis. The sort of issues that lawyers are concerned about at the moment. We hear a lot of talk where, even if it's a psychiatric assessment, there'll be questions, well, is there a credit issue? If there's credit, we tend to want, face-to-face consultation. Do we have surveillance that is in some way relevant that we want the claimant to discuss with the doctor? They're the sorts of things that are going to be relevant, I think. So the answer to your question, it's not a one-size-fits-all. In some cases, there are definitely going to be scenarios where a report is said to be of less significance because it didn't involve a face-to-face consultation.
Okay. Okay, so far tonight there's been a lot of it depends and depends on the circumstance and the situation, and I think that's, you know, that's just a sign of where we're at in this process. So thank you for your comments, and I think this will play out over time as we get more experience in undertaking telehealth or video conference IME assessments. Thank you for that. A few questions around which kinds of assessments, telehealth assessments or video conferencing, should not be done. And, you know, as we've noticed so far, and when you look at the Q&A that's coming up in the chat, there's certainly a lot of things to consider. So, Leanne, a question to you: how do you make decisions like this? What's the process that CIRA has undertaken to identify what is and what isn't possible in terms of examinations undertaken by video conferencing?
Look, so CIRA isn't mandating which assessments can or cannot proceed via video. So we've provided guidance on factors that need considering for both the referring party and for the examiner themselves. But as I've said before, it's a case-by-case basis. And I suppose an important factor is, regardless of the method of assessment, that the clinical justification that's provided in a report is a really vital component, but then that applies whether it's a face-to-face examination or whether it's an examination undertaken by telehealth.
Mm-hmm. Okay, and Brendan, just in terms of in-house with Suncorp, you know, how are the claims management teams determining the kinds of requests they put out in terms of assessments? Are they nominating video conferencing or not, or how's that decision-making process happening?
So it's generally, as I sort of said from the outset, doctors that feel that they have the capability, and customers that want to do it. We are absolutely supportive in respect of that. I mean, injured people should absolutely be given all of the opportunities to, you know, explore their entitlements and have access to the professionals to do that. And, you know, insurers and defendants and employers, people, I suppose, you know, are funding a lot of these things, have absolutely every right to be able to, you know, do their own investigation on this. Ultimately, and I think it is the right approach, the binding determination should be made by the independent bodies, MAS, the dispute resolution bodies that we have. But look, I want to introduce a sort of story, because, you know, I was talking to one of our own doctors in relation to this, and we've been doing a lot of work with psychs in respect to video conferencing, because, you know, it's a history and it's the right thing for the person as well, in terms of allowing them to provide a history in the comfort of their own home. A number of the psychs that we've addressed saying that they're finding it a better experience and better outcomes. But one of the doctors, and again, he talked about one case specifically, and it was a question whether it came down to judgment, and he set a requirement that a person undertake some neuropsych personality testing as part of his assessment. But he stipulated that they had to do the assessment whilst he was observing them. So, you know, kind of, that's something that you do. He had his reasons for this, but we had a bit of a discussion that, you know, new protocols need to be developed to satisfy all of the parties in instances like that.
Okay, let me throw open a question that's been popped on our question and answer, and I'll throw it open to anyone of our panelists. Are there any absolute contradictions to AV assessments?
So this is Leanne. I would say where it comes to permanent impairment, if the methodology that is prescribed in the appropriate guideline, which obviously depends on whether it's a workers' comp or a CTP matter, if that cannot be complied with, then the assessment shouldn't be undertaken by telehealth.
Okay. Just another query. I think this one's for you, Matthew. The question of what is a credit issue. I'm assuming you're referring to credibility issue.
Yeah, where there may be disputes, for example, as to the accuracy of existing clinical records, where social media might be relevant. Basically, where one side says something and the other side says something different.
Okay. Yep. Okay. Fantastic. Thank you. We're going to move on now and to have a look at the issue around consents. And I'm just wondering, Richard, if you could share your comments around this, please. I know it's been raised by a number of your colleagues today.
Yes, it has, I saw. So look, there's general acknowledgement that a consent form for a face-to-face assessment is quite different to a consent form for telehealth IME. Telehealth IME needs to cover many other issues. It needs, IMEs need to consider the issues of privacy. Who is in the room with the claimant? Are they coaching the claimant? Are they recording the examination, etc., which is, as far as I'm concerned, a no-no. For their own protection, many doctors would like the injured person to sign a consent form which agrees to these extra things, such as having only one chaperone in the room, and that chaperone must remain in full view of the camera throughout the whole of the assessment, that there's not to be any prompting or coaching or coercion from the chaperone, and no recording of the examination, and provide, so all of these things I consider should go onto a consent form that has to be signed, should be signed or must be signed by the claimant before the IME proceeds. And for other things such as providing permission to obtain x-ray reports, because normally we can get x-ray reports when the person walks in the room, one way or another, either they brought it with them or they're in the records, of course, but if they're not anywhere, then the claimant can assist us advising where to get them from. So also permission to photograph ranges of motion, if that's what you want to do. And I've actually done that in some of my telehealth IMEs. I've photographed the range of motion, of course, with the permission of the claimant. They know I'm taking it. I say, stand there, I hold it like this. And I can measure the range of motion afterwards with my goniometer after the assessment is finished. Of course, you can also measure the range of motion on the screen sometimes. But to get, so the consent form, I believe, should now cover all of these extra things that aren't relevant when you're doing a face-to-face. Of course, the IME is not allowed to contact, we as IME doctors are not allowed to contact the examinees until the time of the examination. So these extra items should be included in the telehealth form, but that of course raises legal and logistical questions. So Matthew, actually, I'd like to ask you, what can an IME legally ask claimants to sign when they're located in their own homes? For example, I just gave a list of things. Are there any of those items that you feel you would not be legally permitted to ask the claimant beforehand? That is, getting the whole process signed days before the process, so it's all understood beforehand.
There's some case law, for example, at some fairly high court, in some high jurisdictions, requiring claimants to undergo blood tests, provide hair samples or urine samples for purpose of pathology testing. There's a case law where a claimant was obliged to undergo neuropsychological testing. And the court or the decision maker's recourse, if a claimant refuses to do anything that they deem necessary for the matter to proceed properly, is simply to dismiss the claim or put the claim into some sort of a hiatus. So the answer to that question, Dr. Seckel, is anything that is reasonable for the conduct of the assessment that can be the subject of some sort of a consent form or some sort of an agreement process. Well, we could well end up getting arguments about what is and isn't reasonable. I quite regularly find that some solicitors object to occupational therapists taking photographs in claimants' homes of their bathrooms or their laundries or their kitchens, and they insist on having no photographs taken at all. Other practitioners and claimants don't mind. So the test will simply be whether or not the items in the consent form are necessary to have the assessment conducted adequately. And again, I return to my earlier theme, that will come back to what the weight of medical expertise says is required.
Okay. Would you consider it reasonable to insist that any other people in the room have to remain, and there should only be one anyhow at most, have to be in the camera's view all the time, and that the claimant should be obliged to sign that they won't be taping in any form, audio or video, the procedure, and a couple of the other issues that I've mentioned. Did any of those items seem inappropriate to you?
My view is that My view is it's reasonable, and in my view, anything that is done to try and establish an environment that's similar to a consultation room is reasonable. And if due to cognitive issues or age-related issues or psychiatric issues, a claimant would normally have a support person there with them, then that's something that could be emulated in the home environment. If they would not, then there ought not be anyone else in the room. That's my view.
I think most doctors don't mind having one chaperone in the room, just there as a human support, without being. So I'm suggesting that should be permitted, but acceptable, but that person should at all times be in view, so that they're not seen to be coaching in a way that they would not be permitted to be coaching in the clinic room. Anyhow, so I haven't heard anything. I don't think that you've stated that there's anything that I've listed there that would be, in your opinion, taken not on notice, that would be inappropriate.
No, nothing that I heard, certainly.
Thank you. Secondly, how does an IME get a consent form signed prior to a video IME? Now, again, consent forms are not obligatory as far as the law is concerned, as I understand it, because by virtue of having put in the claim, the claimant has accepted the obligation to attend the IME, and that accepted the obligation that they would have a physical examination. Nevertheless, just about every doctor I know, and certainly I, insist on having a consent form completed anyhow when the person attends the clinic, because it covers other issues besides the fact that we're not going to be assaulting the person because we're examining them without their permission. There are other issues as well, so every doctor wants a consent form, and I've now mentioned many other items that I feel should go onto a consent form for a telehealth IME. So, but let's assume for the moment that that's reasonable, that there should be a consent form. How does an IME get a consent form signed prior to the video IME? Should the referring insurer or solicitor do this on behalf of the IME, noting that this involves coordination of the IME's specific consent form? If not the referrer, how does an IME get it signed? And when many claimants don't even have printers at home, for example, if we provide the consent form via an electronic form, many claimants aren't tech savvy and can't sign online forms. So this all takes out time from the examination and poses coordination problems. My sense is that if we accepted the consent form should be signed, that it should be arranged by the referrer well in advance. But what are your thoughts, Matthew?
There are practitioners who instruct their clients, and they tell us in advance, there's nothing secretive about this, not to sign any forms while they're at the doctor's. So the only way to eliminate those sort of scenarios is to have the consultation as front-loaded as much as is possible. Have all the documentation arranged between the referrer and the claimant's representatives, have it executed, minimise all the non-clinical things, in my view, that have to happen before the clinical process can begin in the examination. So to me, Dr. Seckel, that's a bit of a no-brainer. I think that that should be done between the referrer and the solicitor before the examination begins. And there's a question here saying, well, what will happen if the claimant wants the examination but refuses to fill in the consent form? Well, that's where the regulator, informed by the weight of medical opinion in the fullness of time, is going to come to bear. In my view, and I've talked about the readiness of the legal system for this, what we're going to have to see is some sort of regulatory initiative and momentum build up to perhaps create a standardised consent form, to create a number of standardised protocols that allow these examinations to take place. In the absence of that sort of impetus, I don't think it's likely to go forward very much after the COVID scenario is finished.
Good, thanks. Yes, I think that if somebody's refusing to sign a consent form, I'd have to refuse to see the person, because that consent form is to cover certain issues that I think are obligatory. But that would be my personal decision. Fortunately, I haven't had anybody refusing to sign a consent form for a long time. It did used to happen rarely, but I haven't had experience. Anyhow, thank you for that. What about Leanne? Do you have any further comments on any of those matters?
Look, I agree. A consent form specific to the video assessment is required and appropriate. who actually obtains that. Certainly in the workers' comp system, the majority of IMEs are conducted or organised through medico-legal organisations, so they could perhaps have a role in facilitating obtaining consent. But as was said, as Matthew said, you know, it makes sense for the referring party to obtain that. I know we certainly have some guidelines pre-COVID that where an assessor, for instance, wants to record an examination, that the injured person needs to be aware of that and agree to that before the assessment is even scheduled. So it all makes sense that it is done. We have seen an example of a particular company that were asking injured workers or injured people, to sign a very extensive consent form that certainly seemed to be very far-reaching and beyond the needs of just consenting to a video examination. So the consent form needs to be appropriate for the purpose.
Thank you. And Brendan, have you got any further comments on this?
Look, I'll just reiterate Matt's comment. I think, you know, in this virtual world, we've got to have exactly the same.
Sorry, Brendan. Again, could you come closer? Sorry about that.
Exactly the same standards as you have in a consultation room. It hasn't been ever really raised as a major issue, Richard. So some of the mechanics of the things that you're talking about need to give some thought. But no, I don't really have much more to add than that.
Thanks, Sue. Thank you.
Okay, well, and that's an important point as well, Brendan, the mechanics of some of this new landscape that we're in. Talking about consent forms, there are a lot of doctors who don't work through a broker and go directly, and trying to coordinate that is a new challenge for them that they didn't have when they were seeing face-to-face consultations. We're going to start to look at some of these logistical issues now for the next couple of points, and I'm very conscious of time. Thank you all for staying here. I'm very conscious of the questions. There's fantastic questions that we will answer outside or over the coming days, and we'll also be moved forward to the webinar in 2 weeks' time as well. Let's just quickly touch on the issue of privacy. Of course, security of healthcare records is a major concern or a major issue now for independent medical examiners, with potential breaches being very high, $340,000 for an individual, $1.7 million for an organisation who's found to be in breach of privacy and security of Health Records Act requirements. This includes things like sending documents by the mail, by courier. It involves things like receiving confidential medical information via unsecure emails like Gmail. And now, given that many medico-legal practitioners are working from home and potentially working from home-based computers, it does expose independent medical examiners to a potential higher level of risk. Then you look at video conferencing platforms, and we've all heard about, you know, we're on Zoom right now, but you know, would you recommend it from a medical examination perspective? I certainly have a view on that, but it's talking about, you know, the breaches that can happen when you involve a video conferencing technology as well. We've all heard about hackings and all of those kinds of things. So privacy and security and maintaining confidentiality of healthcare records is very important. So I'm just wondering, I'm going to throw to Matthew and then to Brendan. What are your views on this? Given that an IME is personally liable for any breaches, what guidance can you provide around trying to mitigate these risks? Matthew.
I'm not a practitioner in the privacy space, so my expertise from a legislative perspective is limited, but I'm confident that the same sorts of duties of care, the same sorts of obligations would apply as do presently in a face-to-face consultation scenario. Obviously, a question's been asked, and you just mentioned, Sue, given what we know about Zoom and the security issues it has, it's probably not going to be a suitable scenario for conducting assessments. And that just comes down to the practitioner exercising their common sense duty of care within the scope of their knowledge and with the scope of their ability to manage the scenario. the best case scenario, and Dr. Seckel mentioned before how large the briefs are that go to doctors regularly, is probably for some sort of a Dropbox scenario to be arranged that has all the adequate security measures in place for transferring the documents. In terms of the video connection, I don't have an answer for that. I don't know about the technology, and I question the access that people at home are going to have to the right sort of technology. But the initial answer to your question is simply the general sort of care that would be taken in the current scenario.
Mm-hmm. Brendan, what are your thoughts on this?
Look, I mean, the issue that you actually raise is a massive risk, and you're absolutely right. I think this sort of, you know, in this environment, it absolutely.
Brendan, sorry, come forwards again, please.
It is increasing. It is increasing the risk. You know, I know Sarah have put out some guidelines on this, and I mean, it was news to me that it was IMEs were liable for that. You know, they've stipulated that any of the sources that they need use need to sort of have end-to-end encryption. It is a big risk. It's been a big risk even before this. I know, for example, in terms of Zoom, Suncorp does not allow it. We've been approached by plaintiff lawyers to conduct settlement conferences. They absolutely see the risk in it. We're not allowed to use it. We're going back to the telephone, but again, yes. You know, a portal has been, we're going to a portal now, just even in terms of uploading our documents to MAS and to CASA. You know, that infrastructure is in place between insurers, but, you know, in terms of IMEs directly there, it is an absolute risk. And yeah, I'm sure that you're recommending all of your members that they absolutely ensure that they've got the right, you know, the right hardware and software to mitigate that.
Okay, so the message is very much, it is an important issue, and you do need to be mindful of this when you're choosing your platforms and when you are receiving and exchanging medical health records. So thank you for that. We're going to just, again, look at some logistics around managing telehealth assessments and from a claimant's view. And this has come from a lot of feedback from doctors who've been undertaking video conferenced assessments, saying how challenging it can be to actually manage the setup for this. You often have injured individuals who don't speak English. You have individuals who aren't particularly tech savvy and they don't know how to use a computer. Quite a number of them don't actually have the right devices. They may not have a computer, or they may have a mobile phone. And is that actually suitable for conducting the assessment? Many don't know how to install Skype, how to click on a URL. They are worried and concerned about how the process will actually happen. Audio issues are very common, where many people have got their internal settings on their computer turned down and don't know quite how to do that. So the issues of setting up the consult for a video conference can be challenging on many occasions, and I know firsthand from doctors who have done it that, you know, these are not uncommon challenges. And when technical issues or tech savvy, the ability for the individual to understand what they're being asked to do, when those kinds of issues happen, it can create an inequality for the injured person who's experiencing the technical challenges or issues. And indeed, not all doctors are particularly comfortable with this medium as well. Then you have the scenario where you add an interpreter to the mix, and you need to now work out how to do a three-way, how to coordinate that, how to coordinate the communication. And it can be challenging. These are all things that we have started to see over the last 6 weeks. And of course, that can be managed through prior preparation, but it can require technical expertise and, of course, time, which we're going to touch on as well. Richard, what are your thoughts on this? What are some of the options that are available to support the injured person and indeed the IME who may be technically challenged, so that they're not disadvantaged by the technology, and so that the IME is able to focus on the actual consultation? What are some of the things that are available to try and make this process as streamlined as possible?
Well, yeah, I mean, I'll just repeat what I said before, of course, that as doctors aren't allowed to contact claimants directly. Leanne said in the workers' comp situation they can, but I presume that's only when there's not a lawyer involved. If there's a lawyer involved, again, I think we're not permitted, that is the claimant's lawyer, and we're not permitted to contact the patients in advance. So nevertheless, through the lawyers, I think it has to be the referrer's responsibility. But actually, it's interesting that you ask, because I've just heard of at least one new organisation that contacts and conducts a test run with the claimant prior to the video conference call. That obviously, again, has to be arranged through the various referrers, but that they can resolve the technical issues before the assessment, and enabling the IME to focus purely on the medical aspects of the assessment. Understand that it can also coordinate the signing of the consent form, and can also organise a three-way setup with an interpreter if necessary. It sounds like it might be of use to referrers, and therefore, of course, to us as IMEs. I haven't used them, but at least in theory, it sounds like a terrific service. So, I believe, Sue, because you mentioned it to me yourself as well, that you heard about it, you put it on your website as well, the MEDirect website. Anyhow, I know nothing about it, but it sounds like a really good service. And I think that something like that, either that it could be done in-house by the referrers, or probably more effectively by using an organisation like that, would be very helpful.
Mm-hmm. And it probably depends on the individual IME setup, whether they have a practice manager who can do that, or whether they work for a broker, or whether they're working independently. Leanne, have you got any thoughts or views on that?
No, look, I agree with what you just said, Sue. I think it depends. It will vary again who holds responsibility for setting that up. As I said before, certainly in the workers' comp system, many referrals are managed through medico-legal organisations, in which case it may be their responsibility to ensure the appropriate approach is in place as part of the service that they provide, if the examination is to be undertaken via video. But yeah, in certainly some examinations, it's organised directly between the referrer and the examiner. And again, I think it is a joint responsibility, but more likely to be the referrer that needs to sort of take the lead in that. And it also depends on the doctor's set up, their own confidence in using the technology, and as you said, whether they've got practice staff who have the skills to organise those things on their behalf, or whether they need to sort of use a service like Richard just described.
Okay, Brendan, any thoughts on that?
Look, nothing other than I'd just be repeating what has said, but something that I read. I mean, you referenced there some people just don't have access to this infrastructure. Something I read, that we've learned through this pandemic, that and we're a microcosm of obviously society going about the important work that we do. Technology bandwidth used to be a luxury, becoming more of a utility. People need it. People, we're looking at the just the options to get health, to get treatment, to people that haven't got these things. That they are absolute societal issues that we're a microcosm of. That we're going to have to come out of this and continue the conversations, because some people are disadvantaged. There are people in sort of areas that don't have. The great thing about telehealth in regional areas, we're absolutely getting some people there are telling us they're getting access to treatment and to doctors that they historically haven't done so. But the ones that don't have access to I suppose, basic IT equipment, we've got to find ways to address that.
Mm-hmm. Great, thank you, Brendan. And by the way, folks, I think you just witnessed some Zoom bombing below on the panel. For those of you who missed it, there was somebody who entered the panel who is not a panelist. But there you go, you've now all experienced a Zoom bomb. Okay, we're going to quickly move on. We're in very much the downhill straight now. CIRA has, of course, recently introduced new codes for telehealth, and so therefore the matter of reimbursement for telehealth consults has been raised, with the view that conducting a treating doctor telehealth consultation is quite different to conducting a video conferenced IME assessment, and the sentiment that a video conferenced IME requires much more greater cost and time to coordinate and perform. However, the new fees haven't reflected that level of complexity. So the question is, when considering the fees, are there any considerations around increasing those fees for telehealth assessments or reimbursing services that support the setup of these video conferenced assessments, given the increased level of complexity that are involved in undertaking, preparing, and potentially post the consult, managing the aspects associated with video consultations? video conferenced IMEs. Leanne.
Sue, so CIRA sought some feedback from assessors regarding this issue, and we, via a survey that we recently conducted, and we surveyed approximately 1,000 assessors. So they are permanent impairment assessors listed for the workers' comp system and authorised health practitioners in the CTP scheme. So, or some of the assessors obviously would fulfil both those roles. So we distributed the survey to approximately 1,000 assessors, and the survey went live on the 16th of April and closed at midnight on the 22nd of April. And out of those assessors, we had 262 responses. So some of the questions we posed in the survey were actually around how long it routinely took to conduct an assessment via video and how long it routinely took to conduct assessments face-to-face, noting, of course, that there is individual variation depending on the type of assessment and even just the individual that you're assessing. But the responses that came back showed that the majority of cases from those doctors who responded that they said, the majority of them said that in-person examinations take around 31 to 60 minutes, and the majority of respondents also said video examinations took around 31 to 60 minutes. So these survey responses indicated that in the majority of cases there was not much difference in the time taken to conduct an examination via video versus face-to-face. There were, of course, some variations. We did receive some responses that stated video can take longer, and conversely there were also some responses that stated video took less time than a face-to-face examination. So at this stage, CIRA doesn't hold evidence to say that the fees need to be higher for telehealth assessments versus face-to-face. But I mean, we're basing that purely on that survey response at this point in time. And I mean, there's other factors also. We are aware that there are some assessors who are using, for instance, physios to undertake a physical examination component versus the assessor undertaking that, and that those sort of approaches came in when the travel restrictions first came in. But then again, we've also had feedback that some assessors, particularly when they're working from home and would normally have office space or travel to regional areas on a regular basis, they're saving costs on you know, room rental and reception staff and those types of things and travel. So there's, you know, we're seeing both sides of the coin.
Okay. Richard, I know you've received some feedback on these aspects.
Yes, certainly. The feedback that we've had with the AMLC, and I've spoken to a lot of doctors about this, is quite different to those results that you've were given to you, Leanne. If the purpose of the IME is simply to confirm that the claimant's claim is correct, this might not be much more complicated by video. However, the goal of a properly performed IME is generally to confirm or refute what the claimant is claiming, and the forensic components of that type of assessment take much more time and are more difficult to perform by video. I understand that most respondent referrers, up till now, notwithstanding what Brendan has advised us, that most respondent referrers have been reluctant to refer for telehealth IMEs due to the increased difficulty with the forensic components of the assessment. And my sense is that this might have skewed that survey result, especially as it was 3 weeks ago when most IME doctors hadn't done any telehealth IMEs. And it's quite possible that a substantial or disproportionate number of those responses came from the claimants who are happy, from the referrers who are happy to have the telehealth IME and who are therefore not necessarily looking for the longer forensic assessment that's much more difficult by video. So we're asking tonight's audience to complete a survey now, if you would mind, Sue, on whether a telehealth IME requires less, more, or the same amount of time as a face-to-face IME. You'll see the various options we've put up there on the screen now. So if you wouldn't mind, all respondents ticking whether it's less time, equal time, 10 minutes more, 20 minutes more, 30 minutes more, etc. And respond to that straight away. Now we'll have it up just for a very brief time, and then I guess we're going to have to close. So you tell me when to.
Yes, so we're currently at 40% have voted.
Okay. I imagine that this has been a very, very long webinar, that we've lost a number of our original attendees by this stage. And we're about to finish.
We haven't lost too many, I actually can say.
Oh, that's wonderful.
We started off with a very large number. I think we've lost maybe 30. So thank you all for hanging in there. We're very, very grateful. And, you know, I think it's a reflection of all the questions that you've all put in prior. So thank you so much. We're at 58% who have voted. So if there are any last votes, could I ask you now just to submit your views now, and then I will end the poll and display the results. So
I anticipate that these questions are relevant not just for the New South Wales situation. I know Leanne has given the decisions by our local CIRA for workers' comp and motor accidents, but this sort of question, I think this question is very relevant to everybody. And I realise that there are quite a number of people who are in the audience who possibly have done absolutely none at all, and I'm not quite sure whether we want them to answer this or not. It would have to be a theoretical answer, and therefore, again, not necessarily practically correct, but I'm not quite sure what the response was to the answer survey either, whether there are a number of people, as you would have said about randomly, whether a number of people who hadn't done any had responded to that survey. And I guess you won't know and we won't know.
Well, Richard, actually, there were some respondents who said that they hadn't undertaken them yet, so they couldn't comment. So I think they were quite upfront about that. So, but I mean, we did not go to the level. Sorry, we didn't go to the level of detail asking whether they acted for a particular side or not.
Sure.
So we did.
No,
it was a more general question. Yeah.
No, I understand. But were their responses, even though they hadn't done any, were they entered into the survey? Did they give a figure of how much time they spend on telehealth IMEs, even though they haven't done one?
No. So where they hadn't undertaken them, they were saying that they wouldn't comment on that particular question.
Oh, okay. So I guess our survey should only be from people who've done telehealth IMEs.
Yeah.
Okay.
I'm going to share the results now. On the screen, you should see the results. So essentially we have 25%, or let's call it 28%, who said equal time or less, and the balance said it was taking them longer, generally 20, 30 minutes longer on average or above. Okay.
That reflects the response I get. Okay, so thank you everybody for that. Shall I wrap up now, Sue? Yeah.
Yes, absolutely.
Okay, so until 6 weeks ago, we were all doing perfect IMEs in a perfect world. The world has now changed, and we either take the risk of doing face-to-face IMEs, which is a risk, or at best we can do adequate telehealth IMEs, and in that case, it's only in some cases that we can do adequate. It's never going to be perfect. In an imperfect world, as we're now living in, we can't have perfect answers, and some questions that we put to our panelists tonight can only be answered with further time and experience gained by trial and error. But on behalf of the Australian Medico-Legal College and of all the members of the other medical colleges who joined us tonight, I'd like to thank the panelists immensely for their time, efforts and insightful feedback as we all consider how best to navigate this new landscape. Panelists, you've given us such much clarity, and we've all highlighted more issues that need to be resolved in the immediate future, hopefully. I'd also like to thank you, Sue, and the MEDirect team for your extraordinary time, energy and skills in arranging and facilitating tonight's webinar. You've put in, I would guess, 100 hours at least for this webinar tonight. It's immense. The webinar has been recorded and will be available on the Australian Medico-Legal College website in the next few days. I think Sue's probably also going to download it for herself as well. I'd like to remind you that and it's public access, it's for everybody, there's no special password. This is an educational event that we're doing tonight for everybody who's interested. So I'd like to remind you all that our next webinar will be on the 21st of May in 2 weeks, and will again involve, like the previous one, not like now, it will again involve a panel of doctors focusing on when and how to do telehealth IMEs. We expect to have a surprise guest, as I said before, who's a world authority on IMEs and well known to many in tonight's audience. And we extend a welcome to all our participants tonight to attend that webinar. Again, open to anybody who wishes to, not just, of course, college members, not just our college members. We strongly encourage everyone who's had experience in this new format of IMEs to email tips on how to do them better. Please do email them. On the screen there, you've got the email address. I'm not sure that you can see it all. On my screen, half of it's missing, but it's info@amlcollege.com.au. So we'd really like your tips. These will eventually be collated and discussed at the next webinar and then put into a policy statement eventually. The email address is also on the Australian Medico-Legal College website. And most importantly, thank you, college fellows, for everybody who's attending, for your attendance tonight. We recognise that this will no doubt be one of many steps that our IME specialty groups will take in adapting to this new and challenging environment. So thank you, everybody, and good night.
Thank you.